Okay. I know it may be, we're trying to take bets over here to see how long we'll be here. Hoping to get through section 2 today. Want to be mindful of everybody's time. So it is 6:01, and I will go ahead and call our meeting to order for the March 18th Charter Review Committee. And so first, we'll go ahead with the first item. Regular agenda items, consider approval of the February 18th Charter Review Committee minutes and take appropriate action. So Aaron had sent out the minutes to everybody. Any questions, comments, concern about the minutes?
One item.
Yes.
With respect to Member Mahesh, he's on there as in attendance and absent, but he was absent that month, so we need to strike him from the in attendance.
Okay.
We'll take care of that.
Okay.
You can approve as amended.
Perfect. So I will take, I'll take a motion to approve the minutes with the amendment. Pam? Pam motions to approve the minutes with the amendment as presented. Do I get a second? Second by James. Any discussion? All in favor say aye.
Aye.
Any opposition? So moved. Okay. Second item, review of items requested by review by the city attorney. Now, before we go into that, we do have one item. If you'll remember, we're going to be voting on potential items for consideration at the beginning of each meeting from the previous meeting. So we didn't get through the entire section, but I still want to make sure, just because it's somewhat fresh on our brains, for us to go ahead and vote on one item. If y'all recall, from the previous meeting, we had a number of discussions on items that were kind of kicked back to the city council's recommendations to consider under potential ethics ordinances and things like that. So we don't have to necessarily vote on those. We made a recommendation. And actually, if you listened to the council meeting yesterday, I would encourage you, they started talking about decorum and some of those things. So I encourage you to watch that meeting if you would like to just listen in on some of the things that we were talking about that we kind of recommended to go back to council because we didn't think charter was the appropriate avenue for that. So wanted just to remind you all of that. So there was one piece that we did want to consider changing or adding in this case in section 2.06. And that was, if you go to section 2.06, there are a number of council powers that are listed, and we discussed adding a section that states the council can appoint the city attorney or dismiss at will. And so that was something that we discussed for consideration. And so I'd like us to go ahead and if there's any further discussion on it, happy to discuss it now. And if there is not, I would entertain a motion to add the recommendation to add that section 14.
Can you read that? Section 14?
So section 14 is regarding the council powers.
You were going to add.
We were going to add, so if you look at the list, there's 13 there already, and we discussed adding a section, an additional section, which would in this case be 14, stating that the council can appoint the city attorney or dismiss the attorney at will.
I forget. How is that different than what's current? It's the city manager that does it right now?
Yeah, go ahead.
More or less, city manager does actually make the selection, the council approves the expenditure, so it's kind of a joint decision, a little bit.
Yeah, I think it was just adding clarifying language. Did you have anything?
No, the one thing I was thinking, or at least throw it out is this a big enough decision to require more than just a 3-vote approval or disapproval? Like on the city manager, if you're for the city manager, you got to have a supermajority, at least 4 supporting it. I'm throwing it out just for discussion more than anything.
I think right now you have to have 4.
For the city manager, yes. But that's by charter. For this position, this provision, since we're adding it, is there anybody that thinks the city attorney is of such great importance that
David Berman does. I saw you smirking over there.
Dave, would you leave the room? Anyway, it's just for discussion purposes. If anybody thinks it's significant enough to make a supermajority requirement, I don't care either way.
I think it'd be pretty significant. I think it's a significant change, and I think it would be more representative of all the voters in the city to have input on that and hold the city council more accountable instead of having something where it will come about.
So we could add at will with a supermajority 4 members.
So similar language to what how they have the city manager
Yeah.
reference.
So then we would, so Aaron, the recommendation that we would have, that someone would have to recommend would be to state, section 14, to state the council can appoint the city attorney or dismiss the city attorney at will with a supermajority 4-person vote.
Could I ask, on 2.07, it also talks about the mayor voting on that to make it 4. Would you want to include on this the mayor?
Absolutely.
So you could have 3 council persons and the mayor to make it.
Whatever the limit is, I think, for the city manager, I think is
Well,
appropriate
yeah,
for
if
this one.
you read it on 2.7, it talks about the mayor being able to vote.
Yes.
It was supermajority. Yeah, we can add that.
I like that. Yeah, I do think that because it can be very disruptive to let your city manager go,
Right.
probably
I'm
needs
just
a little
looking
more.
for the consistency of it.
Yeah, I like consistency.
So,
Okay. All right, so all in favor to include this section 14, raise hands. All right, any opposition? I think majority rules, we'll go ahead and make that recommendation. Thank you all for that. And so with that, I will go ahead and turn it over to our city attorney to discuss the items for review requested from the previous meeting.
So what? All right, so I think we've already discussed, there were 3 items, but I think the only one that really was, that we haven't already talked about was whether or not pre-clearance would be required if we wanted to amend or recommend amendments to the charter that would create a 7-member council, which meant that the mayor would get to vote, and add a new council member to be elected at large. So the question was whether or not, in my opinion, pre-clearance would now be required if we wanted to do that from the Department of Justice or from the U.S. Attorney General's office. The answer is, as best I can tell, probably not. There is a judgment that was signed off on in January of 2013 that created our existing 5-member district. Mayor's elected at large but doesn't vote, and then 5 individual council members from 5 defined geographical districts in town. That was established and created by a federal court judgment dated January 13th of 2013. That judgment contains a provision that says that the city is not precluded from amending its election system pursuant to state law and the city charter, so long as any amendment is consistent with the requirements of the Voting Rights Act. So in January of 2013, the Voting Rights Act contains Section 5. Section 4 and 5. The Section 5 was the section of the Voting Rights Act that required pre-clearance for those jurisdictions that were identified in Section 4. Section 4 identified 9 or 10 states. Texas was one of them. A few other states where there were counties involved, and a handful of other states, a couple of other states, where only a few cities were involved. But of the 9 or 10 states, it was determined by the U.S. legislature, by Congress, that voting rights have been questioned repeatedly for years, and so everything that was ever done in Texas that might have affected or diluted voting rights of minorities was subject to pre-clearance. So that, for example, if a city annexed a new territory, pre-clearance was required by law. You'd have to send a letter to the DOJ or the U.S. Attorney General and get them to pre-clear it. Sometimes it was difficult, sometimes it was just a letter and you wait for them to respond. In June of 2013, however, Section 5, the U.S. Supreme Court came out with an opinion in a case called Shelby County versus Harris that as of June of 2013, the Voting Rights Act Section 5 was declared unconstitutional. So when the judgment says that amendments must be consistent with the requirements of the Voting Rights Act, the Voting Rights Act no longer requires pre-clearance for anything. And so I think that if you were to recommend to the council, if the council were to tee up an election to were to approve a new system where we maintained 5 single-member districts with 1 council member at large and a voting mayor, pre-clearance would not be required. Which makes it a little bit easier, if that's what you guys wanna recommend.
And that's regardless, oh, I'm so sorry.
Oh, no, I was just
No, go ahead.
gonna ask, what is the impetus for this? Why do we need an at-large city council?
There was discussion about it from a couple of members last time, and we just wanted to get clarification on whether, if that was something that we wanted to consider, what was within the means of the law, that we would be able to do something like that. I think, I think we're just getting a little more information.
Well, I have a little interest here because I teach
Yeah.
election law, and I actually putting a course together on the Voting Rights Act this week, this summer.
Was that right when I said that?
Well, it's Holder, though. Down here it's.
Oh, sorry,
Shelby County versus Holder.
Shelby versus Holder.
Very famous case. It invalidated Section 4, which was the formula that was based on all of the problems, in the southern states that caused the pre-clearance to be needed. And Section 5 is the mechanism for enforcement of it. All right?
Correct.
So, some of you know that the John Lewis Act was put forward by Congress. It didn't pass because it couldn't get through the filibuster. There were efforts to try to put a new formula in, but so far that hasn't happened. Congress is attempting to try to get that done, but it's probably going to happen this term. But what we're doing here by adding an at-large member is kind of flying in the face of the spirit of Section 2 of the Voting Rights Act. Even though technically you're right, we could probably get away with it. But my question is, why do we need an at-large member? We already have the mayor.
It's not a vote.
Clarify, how does it fly in the face of Section 2?
Well, it flies in the face of Section 2 because Section 4 and 5 are still there, they're just not valid at the moment. Section 5 is still there, and if we get a new formula in Section 4, Section 5 will continue to work. Shelby County did not overturn Section 5, it overturned Section 4. The formula was what they said was no longer valid.
Okay.
So Section 5 is still there if we get a different formula from the Supreme Court. So you're correct, we can do it. But my question is, what is the impetus for doing so?
So the other part of it was the suggestion, or at least the idea that the mayor would be able to participate in more votes, and so would have, I guess, more than just a ceremonial or
What would it affect the mayor's voting? Are we going to be giving the mayor a vote?
Well, you need to, because now if you've got 6 seats as council members, you're gonna have too many chances for a.
So everybody gets a vote now, if you were to go through this?
Correct, so.
And the
I don't
council
know
wants that?
What's that?
And the council wants that?
No, I don't know.
No.
I don't think that was brought up by the council. I think it was just brought up by somebody in the group saying, hey, what do you think about this? Should we roundtable it, which is basically what we're doing.
Yeah.
So,
Scott, and then John, and then Al.
Before we get on to something else, I will preface it by saying, please don't have me, I was a broadcast journalism major. So, unfortunately, I'm into language. And I've also been involved heavily in creating and amending, right now it's the USA Hockey Rule Book, which is about this thick. And under section 201, I just need to throw this out. The council shall consist of 6 members, comma, a mayor and 5 council members. In strict English, that adds up to 12.
No.
I don't know if you want to do 6 members, and colon, a mayor and 5 council members, but if you look under the, if you look under the
Saying there's a grammatical error.
Yeah.
It's grammatical. There needs to be a colon in it, because in strict English, what is in there, the way it's printed, is actually 12 people.
We have moved on from that section, Scott, I'm sorry, we cannot go back, just kidding.
Okay.
I'm just kidding, no, just kidding. So
That's fine.
2.01, you wanna make, and what we'll do if there is something, we'll just take it at the end and we'll vote on it with the rest of the items from, that we discussed this time. So you would like to, make a request to, instead of the comma, to add a colon,
That's-
to
that's
correct the
what it
grammar, okay.
Would the grammatical change like that for clarification be something we have to put up to a citywide vote and all that?
Okay. So that's where I think we had a discussion about, can we put a provision in here that says you don't need a charter review to correct typographicals or grammatical issues?
Yeah, and that's exactly what that is. And I mean, I hated to bring it up,
No.
but we're going through a big rewrite in the USA Hockey Rule, and we're getting all sorts of stuff.
Yeah.
And we have something kind of like that.
Yeah.
And having to rewrite it, because otherwise it allows one team 9 players on the ice.
Yeah, we've done that
Think of
before. So yeah, I will make sure to note that and we'll add that to the list of potential changes, at the end of the meeting. Okay, thank you, John, and then, yeah, John and then Al and then Michael.
I'm fine.
You're good?
Yeah.
Oh, okay, Al and then Michael?
Well, I think it'd be a great idea to have an at-large seat. I was talking to some of the council members in Richardson. My reason would be is these districts get really restrictive. We can't talk to them. If our council member is not available, we can't talk to anybody really because it becomes a problem within the council itself. At large, anybody can get attention from that. And I think that's what's happened in Richardson. I think most of their elections are at large. So this allows them, every member, every resident to be able to talk to any councilman.
If you can't, let's say you can't get a hold of your, I'm just playing devil's advocate here. If you can't get a hold of your council member, you can always call your mayor. Because technically he represents the entire city, right? Regardless of.
And I
Just throw it, yeah.
don't think there's anything that, I mean, most council members I know will talk to anybody.
I know, but
It becomes a restriction.
sometimes they get upset saying like, well, why did you give this person recommendation when they're my constituent? Why didn't you let me know? And it's just, it's gotten that way. And that is, again, that whole decorum issue.
Right,
That is where,
There's too much,
Yeah.
my fiefdom versus your fiefdom
Yes,
versus it's
right.
really all for the
Yeah.
city. It's back, you guys get over it and run the city.
Yeah.
But,
I mean,
And
it's not, they're not gonna say it, but it becomes a big problem between council members.
Well, it could, I think again, it goes back to the decorum piece because when I was on council, we never had that problem. We wouldn't even think about it. So I think it's just I don't know if it's personalities, I really don't know, but it hasn't been a problem before, and so I just don't know. But again, we also wanna prevent things from happening, and so that's why we're having these discussions on charter review as well. And so, definitely some things to think about, because doesn't Carrollton have at-large members? And they're our neighbors, and so I feel like personally we would need to do a little more digging of the pros and the cons and what, maybe, what some of our neighboring cities, why they do it, what are the pros and cons to them. Definitely wanna have a larger conversation about this and I know, I like the fact that we have the information, but I do think we need to have do a little more due diligence and research before we even make a recommendation.
I'll work on it,
Yeah,
the pros and the cons.
the pros and the cons of it. Go ahead, Michael.
Okay, everybody has their own opinion. I think that the system we have with single-member districts, every district in the city is included, that thereby every voter, every citizen in the city is included, and then the mayor is presiding. I'm not sure that we need an at-large. I think it might be, whatever the issue is, I think it might be confusing. That's all I got to say.
Ryan?
I don't wanna put words in John's mouth, but I know he's one that first.
I brought it up.
He
yeah.
brought it up.
I was just thinking that it seems like the pool gets really diluted when there's
as small as Farmers Branch is, and we have 5 districts, if, you know, keep them at 5, have 3 districts, and then 2 of those are at large.
I think, yeah, he wanted more at large. I think the idea was we had a lot of little competing neighborhoods and factions.
And that's
No
where a
one
lot
with
of,
their bigger picture of the city at whole. And I think what everybody here is probably thinking, not wanting to say, is how is this gonna affect balance of power on the council versus my political leanings versus others? And to that, I'd say, probably it won't go the way you want sometimes, it probably would go the way you want sometimes. Cause we've had mayors who are at large that are, were right leaning, we've had mayors that are left leaning. And I think the same thing would happen with this at large seat. So I don't know how it would affect me as far as how I'd wanna see the direction of the council go, but to me, it seems like a good idea to have one or more at-large districts. I mean, we do the same in the state legislature and the US Congress, as far as having local congressmen, and then your at-large senator, state senator, whatever. I mean, we can't have two bodies of legislation at a local level, that's just too much, but if you had a mixture of your districts and your at-large reps, well, then you have people that are looking out for your neighborhood and people who are looking out for the city as a whole. So to me, in that regard, it makes sense regardless of how that might affect the political balance of the city.
But I think the balance changes with every
Well, yeah,
new.
changes.
It changes based on who's in, it changes based on, I think it changes regardless. So I agree with you. I think we should take everything into consideration. My opinion is that we should take everything into consideration. I do think we probably need to do a little more due diligence. I mean, Capel, for example, is similar in size, right? They're about 40 to 45,000. We're about 45, 50,000, depending on, the census, right? And they have 7. I don't know what that dynamic looks like. And so I definitely do think we do need to do a little more due diligence. But I think it's something we should discuss, and the pros and the cons of that. I do think sometimes, we are smaller, and so sometimes, especially when it comes to funding, it's like, I'll bring back the park discussion. It's like, well, I had already said money from the park, and I'm like, well, I want money for my district when there were all those ARPA funds that were coming out, and so I think it's just, at the end of the day, the philosophy should be, hey, we're here for all of our community, although we do have certain areas that we represent with our constituents as well. And so I think sometimes that balance, it just changes.
It won't cost anything, you don't get paid anything at all.
Wouldn't an at-large member more than likely look out for their own district more so than somebody else's district?
That has also been the case sometimes, where they're like, well, I'm from the, and also the other thing to consider too is, we also have some parts of our city that don't feel like they're a part of the city, like the west side, right? They don't feel part of the city, and so it's like, we also wanna be careful of that dynamic as well, as if we do end up doing this, would the lines change? If the lines change, how would the lines change? And so that's another question that I would have regarding, maybe adding another, depending on what we decide to do. So, just a lot of things to think about, I think.
Can I say one more thing?
David done this, David.
Too many
Just keep
Davids up
in
here.
mind that if we add another at-large member to the council, that it will dilute somewhat the voice of individuals in various communities. And that was probably the reason why we had the ruling, as it was a few years ago, to force us to go to single-member districts. So just keep in mind, it may be useful, it might be helpful, but theoretically, you're still diluting members who represent their single-member districts.
So, City Attorney David, your initial discussion about this, when you talked about Section 5, Voting Rights Act, it's intriguing on a 3-2, like 3 at large, 2 districts, or 3 districts, 2 at large, changing the way it is. My concern is the way that judgment came down in 2012-ish. Would we, if we tried to go to a 3 at large or 2 at large and 3 districts, would we run into another lawsuit saying, hey, because that whole thing, it forced us into, or put us into the district so there would be a minority-majority, at least one minority-majority district. And so, as much as I kind of like the concept of maybe 3 districts and 2 at large, I think we would need to look real closely at how that decision was written and the judgment was worded to see if we can even consider a 3-2 formula.
And the other-
We could do a 3-2 formula. Whether we would be challenged or not, it's up to whoever wants to sue us.
yeah.
The original lawsuit, I think, was funded and pretty much promoted by ACLU and civil rights entities or organizations. Now, the concern is ensuring we're protecting voting rights for minorities and having, I don't know, 3 districts and 2 at large, of course, would depend on the way that those 3 districts were drawn. It would be a pain in the neck for us to have to go through the exercise, but it could be done. We would draw the 3 districts to ensure protection for voting strength. But the easiest way, I think, what was on the table was the 7-member district. 7 members is very common. 5 members is the same format as a type A general law municipality. Cities or towns that have populations of less than 5,000, or smaller towns, a 5-member district or 5-member council works. For larger cities, in my experience, it's just been that it's better to have 7. In some cities, like Dallas or Irving, you got like a dozen, more than a dozen.
14.
Yeah, 14, which is just, oh my gosh, I don't know how to get anything at all.
Well, they also
They
have
don't.
like, yeah.
So this process, I undoubtedly, the city would have to hire some voting rights experts to get into all what the acronyms are, CVAP and VAP, and look at citizen voting age population, minority voting age population.
It'd be like redistricting all over again.
It would be,
That's what it is.
well, it'd be that,
Not like
plus,
it is.
we would have to create at least one minority majority district, so
Which
we
we
would
have
end up.
now.
We have now, but if you had 3, and you still had 5, and you did 3 districts, 2 at large, you're still gonna have to figure out, one of those 3 is gonna have to be a minority majority, which means we're gonna have to get the census, get the expert in there to see if it can be done. I mean, the experts are out there, it's just, it would be a time-consuming process, and probably
And it would
an
cost money.
expensive one.
But that
The
would be
other
the
thing-
case, keeping the districts the way they are now, just adding an at-large and the mayor as a vote, right?
Yeah, but the other thing I want us to be careful of too is one of the reasons why we went through a lot of these discussions back in the day, and David, you know this, right? It's the fact that the people that were running from the same neighborhood, right? So that was part of the issue, is they were all coming from, I think, the Brookhaven area.
Gatwood.
Living, blocks away from each other. And so again, it's perception too. And we've kind of done, in my opinion, done a good job of moving away from that perception for our city. And I would hate for us to go backwards when we've done so much to go forward. That's my personal thought on that.
Yeah,
Yes, Al, go
when
ahead.
in doubt, look up ChatGPT, there are 6 advantages that they have. And I'll send it to you.
I'm gonna look up 6 advantages. I'm right now.
That would be great.
Al's 6 advantages.
Cristal's 6 advantages. No, I'm kidding. No, but I think there are pros and cons to both. I mean, so I think,
Yeah, I would
Go
like
ahead,
to
Chris.
see more voter participation.
Mm-hmm.
We don't have enough people voting. When you see elections decided by less than 100 people,
Yes.
less than 100 voters.
I'm not sure we've had any, I don't remember any that, I mean, usually it's 300 for each side. If you get 500 to 700, that's your average turnout, which actually, in
But I
Branch
think here,
turnout
just
is
recently,
higher than
16.
I don't know about that. I know when
16%.
Cristal lost to Omar, there was like 150 to 200 votes.
You're right,
That was it.
that was
It was
District,
pathetic turnout.
that was District 1. District 1
Pathetic.
historically had the lowest voter turnout, and then Brookhaven had the highest turnout. And then you had, what is District 4 now, had the next one. So, but it was really, what is District 1 was the lowest turnout.
Yeah,
But that was before all of the west side has been built out, so that could change recently, so.
And District 1 has always been challenged. Just the recent election, in District 1, I think it was less than 100 votes.
I mean, I'm a precinct chair, so I get the numbers, and I'm looking at, when I look at the numbers on the November election versus the mayor election, there's a drastic difference. I mean, 16% is basically, if I'm not wrong, but 16, there are 22.
well, that's why, and that's why Dallas, has moved their elections to November,
Yeah,
which is a whole nother conversation.
So
But
we've had.
we'll talk about that later,
Right.
in section, I think, 7. No, I think it definitely warrants the conversation. So I think, how about we do this? I think a lot of us have a lot to think about now that we have this information. I think we should maybe think through this, see if we wanna come, we're still gonna be talking about section 2. And then maybe we can, if we have time, we can bring it back up at the end, but I still think we maybe need some time. Like, I would like to talk to my colleague, at Coppell, to see kind of what the pros and cons are there, because they have 7, they're similar size. So maybe we can bring it up at the top of the hour at our meeting at the next month to have the discussion, since we'll still technically be looking at section 2 voting, items from this month. Does that sound okay for everybody?
Yes,
Okay.
thank you.
That way we can move forward with the next section 2.07. Thank you, Attorney David. There's like 3 Davids up here. For the information. I know.
City attorney.
Okay, well, thank you so much. And so I would just encourage you all to maybe, do a little bit of research on it. And then we'll bring back thoughts and we'll talk about it at the top of the meeting, in April. So with that, thank you, Scott. We've noted the 2.01 edition, grammatical errors, so I appreciate that. The next item, so on our agenda is we're gonna go ahead and review the next section. So we went through section 2.06, so 2.06, so we're gonna start with 2.07. All right, and of course, my computer decided to. All right, does anybody have anything they would like to discuss in 2.07?
Just a question, is it common in other places where they say no former member of council shall ever be appointed city manager? Is that standard amongst other places? Others? Don't know. Has that ever been an issue with somebody who might be extremely qualified?
It's not very common.
City managers are different breeds. You gotta, typically, if you're a good city manager, you've taken a whole lot of courses and education. You got a good track history.
Council members don't.
A council member doesn't have near the experience on all the issues they're gonna run into.
Okay.
Unless, of course, they were already a CEO of a fairly good-sized operation. But everything in city is vastly different than a private corporation for the most part. A whole set of different rules apply.
It's generally not a politician's role.
It is not a.
The reason our charter provision is to avoid a council member from campaigning and getting himself or herself in line to be the next city manager, to run over council and serve them so that they can be appointed to city manager.
Okay.
So this means the council meeting, the Farmers Branch Council, like former city manager of Addison, or a former council member in Addison, would they also not be eligible? What does the council mean? Our council?
Yes. What's capitalized?
It's capitalized, so it's defined term.
And it says the, not a. Right.
And you've called it the council a million times elsewhere in the stuff.
So it's not that a former council member can't be a city manager, it's that the former council member of our council can't be our city manager. So it has
That's the
more
way I
to do
read
with
it.
the inside knowledge rather than, okay.
Okay, all right, well then we will go ahead and move over to section 2.08. Any items to discuss there, any changes, recommendations for 2.08? And we do, and I have noted the ones that we received from council, so I'll go ahead and, if there is an item for that section, I'll let you know. We don't have any right now for 2.08. All right, 2.09? $2.10? $2.11?
The first sentence in 210,
The first sentence is,
Yeah.
okay.
when I read it, to me, it just seemed kind of wordy.
Okay,
And let me see if I can remember how okay, the city, I thought it should read, the city council shall not direct or request the appointment to or removal from office of any person appointed by the city manager or any of the city manager's subordinates. That's kind of the way I thought it would be worded, but the way it's worded now, neither the city council nor any of its members shall direct or request the appointment to or removal from office of any person by the city manager. See that, I kind of got hung up right there.
Shouldn't the word appointed be in there after person before the word by?
I think so. Technical correction, that's a good.
Yeah, I got hung up there. When I read it, I had to kind of go over it a few times where
okay.
it didn't quite make sense. And I thought that the sentence just ran too long. But,
So section 210,
yeah, the city council shall not direct or request the appointment to or removal from office of any person appointed by the city manager, is where it should be worded.
The language nor any of its members needs to be in there too. If you simply change it to the city council shall not direct, and
So-
that means that the
So
council.
what's the difference between the city council and the members?
The city council can act as a whole in its official capacity, and then the individual city councilman or the mayor could say, well, hey, I have the ability on my own to go and direct somebody to do something. So it's just clarifying that it, neither as a group nor individually you can do it.
Oh, okay.
We actually found
That's
that
kind of the way I.
pretty strong. If there is a teller at the counter who has a reputation of being rude and disrespectful to the residents who come up to conduct business with the city, hypothetical, city council member gets complaints from their constituents saying this person is very difficult to deal with, under this, the city councilman could not go to the city manager and say, you really should discipline this person? That seems a little strong.
That's the intent of this is the city councilperson or the council should direct it to the city manager to
Yeah.
take care of.
you can do that now, like you
Yeah,
can.
well, the second sentence covers that. It says,
Well, it
however,
says-
yeah, the council may consult with and advise the city manager. Make inquiry regarding the appointments or removals, may express their opinion in regard thereto.
They can give recommendations and insights to the city manager, but at the end of the day, it's the city manager.
Yeah, those two sentences are somewhat contradictory.
Well, they're not. The first sentence says that the council can't tell the city manager to hire or fire somebody. The second sentence just deals with making inquiry or recommendation.
Basically, the way we always interpret that is, we can suggest to the city manager that it perhaps would be in your long-term interest.
Okay, I believe this read, so
Don't
I don't
listen to
want
that.
to, as long as the council can talk to the city
No,
manager
they
and
can.
say,
Yeah.
this person merits
Very
some
well.
counseling.
Or we've been advised that there's
Yeah.
been some incidences, can you please look into this for us? We just try to do our due diligence with our inquiries, yeah,
Okay.
we think that can happen.
Thank you.
So then, going back, Chris, to your recommendation, Aaron, did you record the potential change for that section by chance?
The first sentence?
The first
Yeah,
sentence?
I got it.
Okay, then we'll make sure to bring that one up for consideration as well.
Okay, well.
Just for clarifying language, because we've
And I
been
think
doing
David
that.
and David kind of,
Just add the appointment.
well, no, yeah, because, and I got hung up between council and members.
Yeah.
Yeah, that means by majority vote versus any individual going to the city manager saying you must hire this person. All right.
So is there any ambiguity in just using the word appointed alone? Because we all use the term that the city manager hires somebody. We don't typically use the word the city manager appointed somebody.
Well,
I guess they appointed to a director's role or assistant director.
I don't know. It's just a suggestion, but I'm willing to listen because when I read of any person by the city manager, to me it sounded a little confusing.
And you were right to be confused because the word's missing.
Yep.
Okay,
So we'll just need to include that word as the recommendation.
All right.
Okay? So section 210 and
That's a good catch.
okay, anything else for section 2.1? 2.10, yep, 2.11,
Thought we were going back.
2.10, not 2.01. So, okay, next section, section 2.11 to 11.
I'm just wondering why we give the city manager the gatekeeper role in this section. Creating an ordinance, changing, abolishing offices. But I'm not seeing that he needs to be the sole gatekeeper.
Are you saying they should go with or without the recommendation of the city manager, is what you're saying?
do they have to wait for the recommendation of the city managers?
Right,
Yeah.
or do they have to do like I said a minute ago, is, well, we would like you to recommend this. And if you don't, you might want to think where you're going next.
But
So I just,
what it says is that upon recommendation of the city manager, so the city manager has to come to council and ask.
The city manager
That's what he's
generated
questioning.
the
Yeah,
request.
That's pretty clear, isn't it?
well, it's clear, but what I'm saying is, why should the council be hamstrung? They can only consider these actions if the city manager recommends them.
Because I think, because I think that, you know, it's like we appoint the city manager, but the city manager is the one that does all of the hiring and the firing and all of that. And so I think it's kind of like that balance. And that's how most cities are run, in my experience.
But if you strike those 7 words upon the recommendation of the city manager, all it does is remove the precondition, which may or may not be necessary.
I don't, I think the council, if they want to add a department or merge 2 departments because they decided they've studied it and do they,
Then they would make the recommendation to the city manager, and the city manager would then say, okay, well, let me look with my years of expertise as a city manager and see if that's something that would be conducive to our city, and then they would make recommendations to why or why not. Like, we can still do that.
So they recommend to the city manager, we would like you to consider this, and then he comes back and says, I've considered it, so I recommend you do it. So that's,
Yeah, but I think for me, it's a balance. Like, I can make a recommendation saying, okay, I've seen that the city of Dallas has the Office of Community Care. You know, I think we should have something like that, which actually did happen. And then they came back and said, well, from funding mechanism, we don't get block grants because we don't meet the, population threshold. So then, we would have to pay, get money out of the general fund that would then, and this is the mechanism that we use to be able to support our nonprofits. And that's exactly what happened, because I'm not a city manager. I know what worked in other cities based on my personal experience, but I would want to have the city manager look at it more holistically based on their expertise and what they've studied to do and their experience. I wouldn't feel comfortable making that decision. Again.
I hear what you're saying.
I think David might be concerned that you have a city manager that doesn't want to do what a majority of the city council might want to do, right? To which
Well,
I'd
then-
say you can just fire
But
them.
they can just fire them.
You could, it could be a harsh reality, which is,
Yeah.
so. Okay.
Patrick?
I have one other question on this one, maybe it's just me, but the city council, however, may create, change, or abolish offices, departments, or agencies, but are those defined anywhere? I mean, what are they authorized to create, and how are those things different? I actually would have expected those to have been capitalized in that context and defined somewhere.
I think there's,
So I went back and looked for, well, what is an office? What is an agency? What are these things that the city council can create? I don't know.
Yeah, I mean, in all my years, I don't know of an agency or an office. We deal in departments. So that just may be one of that, as attorneys are prone to do, people that write documents like this, they string extra words in. So,
but that doesn't mean a city can't have
right.
an agency. I think sometimes they'll use inclusive language just to make sure that we are, or non-inclusive, basically not to limit us in case we ever did want to do some.
Again, those are not defined.
So we do have,
What departments are authorized by this charter? Offices and departments and agencies are authorized by this charter.
so we have, I suspect agencies would be the things that we have, like the PIDS, Public Improvement Districts out on the west side. There are, you know,
TIFs,
David, city
there's-
attorney, you may have, help me with some of the other things that the city has that are not your typical departments. We have the PIDS,
We have the Calwood Improvement Authority.
Doesn't this charter talk about the establishment of a police force and a fire department?
Yeah, that's in there.
police department, fire department.
So-
The
I
department.
mean, I'm more concerned that you would want the city council to be able to abolish something that's outlined in the charter at all.
Well, it has that catch-all, you can't, other than officers, departments, or agencies established by the charter, so that.
Other than.
Yeah, that's,
Okay.
yeah, so those are sacrosanct, and it's just Department
No,
of,
I read it wrong. Okay, you're right.
so, for instance, the historical park department could be abolished. The recreation, sports and recreation, parks and recreation could be abolished. So,
Okay.
all right, I threw it out for consideration, that was,
Did y'all talk about it last time when you shared the
we did not.
charter?
Nobody looked at this one, or had any concerns about it, but I thought it was worthy of at least kicking around.
Yep.
So, nobody's bothered by it, let's move on.
Okay. Yep.
I see your point, but.
It goes back to the city manager's going to be responsive to the council out of potential concern for his longevity.
Yeah.
So if a council says, look, we've got some issues here, and they're well founded, the city manager's gonna go look at them and give them a thoughtful analysis. So I'm good with it the way it is.
Okay.
All right, anything else for 2.11? 2.12?
I've got,
Yes, Chris?
the last word in the first sentence, for disability, that sounds kind of general.
I comment on this, I know that this wasn't something that was generated by the council, and I know that the timing is really, maybe inappropriate. I've had circumstances in other cities, not necessarily type A, but home rule cities, where we had an errant municipal judge. A municipal judge that was just nutty as a fruitcake. And let me put it that way, she was nutty as a fruitcake.
Thanks for taking the legalese out of it.
So, the charter had a provision in that city that was not too different from this. Under state law, in the absence of a charter provision, a municipal court judge in a court of record, like we have in Farmers Branch, can only be removed in a couple of different ways that are extremely difficult. The first and most common, which I've never seen, is by a lawsuit filed in district court alleging incompetence, malfeasance, or misconduct in office. It requires a jury trial and an order from a court to have a judge removed. The other way is if a judge violates the judicial canons and the Commission on Judicial Conduct orders the removal. And both of those ways are extremely difficult. The second way almost never happens except in the most extreme circumstances. And we ended up having to buy out the judge in that city, and it cost $150,000 or more to buy out the judge to make her go away. It was not Farmers Branch, and I say that initially it's a bit inappropriate for me to talk about it now because we just had a turnover in our court. But my philosophy, my firm belief is that because state law says you can only remove them for cause unless the charter says otherwise, that the best charter provision is one that allows the council to remove a municipal judge either at will or for cause, which is not specified as incompetence, misconduct, malfeasance, nonfeasance, or disability, because each of those terms have some specific legal meaning, and some of them are actually defined in the local government code. Ideally, my recommendation to you all would be to consider a change of that provision so that it removes disability altogether. I'm not quite sure how that would pan out, but it would just simply say the municipal court judge may be removed by the council at will, or for cause,
Yeah.
without specifying those different grounds. That makes sense?
Yeah.
I like at will.
I like that.
And you understand how difficult it is for the council to fire somebody. It's not easy to do, and it requires, among other things, public hearings. If they wanted to consider the removal of a judge in an executive session, the judge would have the ability to compel a public hearing. And so it can be or could still be a painful process, but it's not something that would ever be done in secret or behind closed doors.
So your recommendation would be to change the language to say, removed by city council at will or just at will, period.
My first recommendation, the ideal would be that this charter provision would read, the municipal court judge may be removed by the city council at will, period.
Okay?
Not for cause.
The second recommendation, if that one's in there, would be, subsidy with for cause, but without enumerating those different grounds.
So
I move we change it to at will.
Second.
Yeah, I can tell you guys stories about what she was doing, and it's just, oh my gosh. Not in Farmers Branch, different
Yeah,
city.
when I read disability, I just thought of physical impairment.
The disability, I think, would
And
be.
accommodating that individual with, by prescribed by law,
Right.
such as ADA or.
Yeah, if we had a judge with this charter provision, if we had a judge who did have a disability, federal law would trump our charter and our own ordinances. We would be required or compelled, even if we weren't so inclined, we would be, to provide reasonable accommodations.
I don't think you could get a city council to try and remove someone just because they're handicapped. I think they would all do it only if it's disability of.
Can you
mental
imagine how
faculty.
hard that would be?
Okay.
You could get 5 people to agree.
So I think we have a recommendation to, from a couple of our members to change the language, that the municipal court judge may be removed by the council at will, period, and removing the rest of that sentence. Any other discussion? Yes,
Well, I actually prefer the for cause,
at will,
for cause.
Instead-
Why do you want to stop it at will? Because there needs to be a reason.
I understand that.
And there, to me,
Then you gotta prove it.
somebody in the council may just not like the guy or the woman, so.
All right, I understand, we have 5 council members, it requires a majority vote. So one council member who may not like or may have voted with that particular judge wouldn't necessarily be able to have it accomplished. And by the way, when we talk about the quorum requirements, which we'll discuss later, there may have been a possibility where at will could have been commanded by one individual. However, in theory, at will makes it simple and unquestionable. If the council has a reason to terminate a municipal court judge and does not want to go through the bloody public trial process of establishing cause and stating that on the public record in front of the entire world and embarrassing the judge at the end of the day by doing that, they would have a reason for terminating the judge. At will means that they don't have to state the reason for that termination. And it makes it so much easier to do. It is unusual for, in fact, I've never seen it happen before. No, I shouldn't say that. I saw it happen only once in about 40 years where the council removed the judge at will with no explanation and for no apparent reason. But I've only seen it done one time, and only once. Every other time, it's been a painful, difficult process. I can tell you stories about the judge that I've talked about before. Oh my gosh.
But thank you for that explanation.
I call
We
it a question.
understand, it's easier to do without, we won't get sued.
okay,
I'm good, thank you.
okay, all right. All in favor for making the change? Okay, making the recommendation? All right, any opposition? Okay, we'll go ahead and,
I'm sorry, Mr. Bagby, did you have your hand up for opposition?
Well, I kind of agree with David. It seems like there should be some cause.
Okay. But I think the idea is, generally somebody's gonna get terminated for cause. I think the idea with that will is you don't have to go make it a public statement why you did it.
That's what I'm looking for, is a public statement, some accountability as to why you're doing it.
Most people
I
don't,
think,
there's no public statement of why they got fired.
And we're at will
It's
state.
an at-will state. Why
yeah,
should it
exactly.
be that?
Well, so you can have a municipal judge who, every speeding ticket or every traffic ticket just says, acquitted. And they be doing 70 in the school zone. Do you really wanna have that guy on there? And do you need to express to the whole world that this person just would not enforce your traffic laws? Yeah, at will gives you the ability to have a reason without having to muddy the water. As I think as David attorney, city attorney said, is you don't air the dirty laundry effectively.
So we'll add this, and then what we'll do is, like I said, at the beginning of the next meeting, we'll just call an official vote to make the change of the recommendation. Is that okay with everybody? Just to give you some time to think through it? Okay. All right.
Wait, I'm confused.
Yes, go ahead.
Do we have to vote?
Well, sorry, my apologies. We voted on the recommendation, to move forward with the recommendation instead of just writing it down. You're right. We usually vote on it at the beginning.
And I think Aaron was asking for clarification as to what his vote was.
Okay.
My vote was no.
Okay. Okay. So for that one, for the other three, we didn't. So for this one, do we wanna go ahead and move forward with that, or do we wanna just take some time and go back?
Move forward.
Move forward, okay. So, Al, because we are gonna go ahead and move forward with this particular vote, did you have something that you wanted to say about it?
No.
No, okay. All right, then we'll move forward with that one.
Crystal?
Yes,
Sorry, Dave.
no, go
Can you
ahead.
just clarify what duties the municipal court judge has here? Is it just like traffic tickets and that kind of stuff, or the enforcement of potentially
ahead.
unconstitutional ordinances?
All class C misdemeanors, which includes all traffic tickets, virtually all traffic violations, as well as class C misdemeanor assault and theft. They have jurisdiction over certain limited civil proceedings like ownership of seized, determining ownership of seized property. But by and large, it's traffic tickets, public intoxication, possession of drug paraphernalia, C misdemeanor assault cases.
Our judges usually stay here for a really long time. And our judges historically usually stay for, they're usually stay here for a really long time.
Is the municipal court judge an employee of the city or a contractor?
They're an employee, I thought they were an employee.
That's a mixed question.
Okay, I was just.
But I think they're regarded as employees. Yeah, that was, it's funny that you asked that question, it was subject of a great deal of debate and discussion.
Okay, I was just,
Yeah, good question.
I thought it would be germane to everything that we just discussed.
Okay, moving forward with 2.13, I had a grammatical error with the double periods, but that's the only thing that I had for
Give it a spot on your screen.
2.13. No, I double checked. Double checked.
Double period, is that for
Yes.
emphasis?
There are two people.
It's a partial ellipse. Put it on the ballot.
Remove the periods. That's why we have that provision, y'all, that we're gonna add. We don't have to do that anymore.
See, that was at 13.
Yeah. Okay, anything else for 13?
Which is if the council, two council members or mayor call for a special meeting, then the city, it's somewhat vague about the city secretary has to notice it. Doesn't say anything about in compliance with the TOMA rules on timing and posting and all that. So the only thing would be really, put something in there that says in compliance with state law.
But I think that's always a given,
I think it is, but it's.
because I think we haven't, then if we did that, then we'd have to do it for the other.
Does that fall under enumeration of powers?
Yeah, that's fine.
At the very beginning?
Okay, anything for 2.13? Okay, 2.14, we did have a couple of council items for review. And so they were proposal to reduce the quorum from 4 to 3 by Mayor Lynn and Councilmember Reed. And then The second was discuss abstentions by Mayor Lynn. So does anybody, before we get into those two, does anybody else have anything else regarding 2.14? Chris?
And the second sentence, I believe it's obsolete because it doesn't reflect the electronic proxy voting that we currently use in the council chamber.
The aye and no.
Right,
Yeah.
yeah. So that everything now is electronic, so.
Though that system has failed from time to time.
Yes,
Just to meet
it does. We resort back to hands and I.
And then I think we should put, voting shall be by aye or no on roll call, comma, by show of hands, comma, or
Right. Just to
electronic
include-
voting.
Exactly.
Okay,
That would be consistent with the way it's done now.
yeah.
I would just say all voting shall be by record vote.
Yeah.
And then let the council
Okay.
or the mayor.
Or,
There you go, that would be
I have these thoughts about somebody being really persnickety and say, well, you didn't say aye. And so that's not really a yes vote. You said yes. So, I've run into people that are really dogmatic, and so sometimes I worry about things like aye.
what did you
and
suggest
over-
by it?
Voting shall be by record vote.
By record vote, I like it. All inclusive, all inclusive based on what the mayor,
I had something on this one.
Okay.
Should we have some kind of carve out here for an exception to what constitutes a quorum, during national emergencies or, when we just had a pandemic, if it wiped out half the council, you don't have 4 members for a quorum. Should we say percentage of, you know, the living councilman? I mean, I'm just thinking worst case scenario, you know? I mean, in that case, probably no one would care about local government anyway. But, I mean,
I would.
I think we have an emergency protocol written that talks about what the succession of power is. It doesn't necessarily, you're exactly right. Who's going to sit there and fight it if we've just been, hit with a F5 tornado? Nobody's gonna sit there and say, we don't have enough council members to decide that we're gonna go and get Capel to come in and run our fire department for 6 months. So I think like you, but we've got a protocol in place that covers that. I don't remember exactly where it is, but we have the Emergency Powers Act, for lack of a better word.
okay.
That's part of emergency preparedness in our emergency operation plan.
it's not part of the charter, it's a part of like the, I think it's part of the. Okay. All right, so, let's go ahead and talk about one of the, recommendations. So one of the recommendations is reduction of the quorum from 4 to 3, made by 2 of our council members. And I think some of the reasoning, like if I'm looking at, the recommendations, I think it had to do with, regarding partly something that we'll discuss in the next section related to, the addition of meetings. The ability for people to kind of meet, 3 people are able to meet in private and ask to add a meeting to the agenda. I think that's where this, recommendation came about from, I know from Councilmember Lynn. And so I definitely do think we need to discuss this. One of the things that I wanted to kind of just share, and I think, Chase, you kind of mentioned it earlier as it relates to just having enough people to ensure that we have a true representation of the council. And I think reducing that can also have, pros and, have some cons to it. Just wanted to share a couple of things that, thoughts on this. Lowering the threshold allows a 2-to-1 vote to pass on a motion, meaning the minority of the total membership can approve actions. It can result in, decisions that may not be as representative of the full council or of the full community. Potentially reduce legitimacy, maybe disincentivize attendance. Lowering the requirement can correct a bad situation with the worst remedy. And then lack of diverse input, right? If we don't have more people to constitute a quorum, then we may not have more voices to be able to share their concern, for whatever reason they might not have a quorum. Just some things for us to think about as we look at the potential change of the language.
Can I ask a question?
Sure.
It sounds like quorum definition has two different meanings. One is how many people you need to conduct business and have a vote that is law. The other one is the number of people above which you are subject to the Texas Open Meetings Act. And so, it's almost like you need two different quorum numbers, because those are really two different things, right? I get the drive to have it to 3, because what I think people were driving at is we don't want 3 people to meet out of quorum and make decisions and then bring it to the meeting. So I don't know what the solution is,
Yeah.
but it's the two
I know,
different meanings
same.
of quorum.
Can I ask Dave,
Go ahead.
what is your understanding of walking quorum? I always, when we were on council, we were told a walking quorum would be 3 or more, and it was designed so that myself, Harold Freilich, and Tim Scott didn't go over and eat in a corner and talk about, okay, this is what we want to do, and so we know we got the 3 votes we need, and even though the quorum in a meeting's 4, we got it all done, and that's the whole idea behind the TOMA, the Texas Open Meetings Act law, is to prevent that kind of behind closed doors discussions, and so that's a real, with 4 being, with quorum being defined as 4 here, you don't necessarily have that same protection from behind closed doors discussion. So David, the question is, can we have 2 different definitions? One for quorum for the purpose of being able to move forward and conducting the business in a council meeting, and one is for purposes of TOMA, it is 3.
I just
Or do you
don't,
need to
yeah.
look at it?
The 2 are really synonymous, you can't have 2 separate definitions. I will say this, our government, apart from the single-member districts, is structured in substantially the same way as type A general law municipalities. A 5-member council with a voting mayor. Under state law, for type A general law municipalities, a quorum is 3. The problem that you've mentioned that has been referenced is you can have, and we have had this happen for a long time actually, where 3 members would get together by themselves outside of an open meeting. They would discuss and come up with conclusions, and when the council meeting occurred, the decision was already made. There was still discussion, open discussion, but it was pointless and had no meaning because the choice had already been made. That's why under state law for type A general municipalities, a quorum, a majority vote is 3. Now the walking quorum concept is a bit different. If, for example, you had a 4-member quorum under our code, if we had 3 members getting together and talking about and just pre-deciding an issue outside of a public meeting, that's not a violation of the Open Meetings Act. But if any one of them were to communicate and to discuss or deliberate on that topic with any other council member, then that makes 4, that's a quorum, and that's a violation of the act. The walking quorum concept is it prohibits a gathering or a discussion among a quorum of the members, not all at one time, but in a series of communications. The one council member speaking with others, or each council member one at a time talking with another one, so that the number of people involved in the transaction becomes a quorum itself. You know, the problem with, and the reason why council members are asking you all to consider this is just that. You will have 3 council members that will meet in private, perfectly legal to do that. They will pre-decide issues, and when you have the council meeting, there's no point in even having a discussion because the decisions are already made. I understand the problem if you have 3 council members present at a meeting, then 2 of them is a majority and they can vote.
And that's what I think, and that's what I wanted to just bring out there is, if we change it for the quorum, it's for everything, and so, for the council meeting, then we would have 3 people, you know, making those decisions.
Could we, I don't know why we couldn't, but you're gonna tell us why if it's.
I'm thinking, you might not, I might wanna see you get drilled.
Well, I'm thinking you have kind of, you know, a but phrase that says the quorum is 4, however, well, if it's 3, if we changed it to 3, However, if there are only 3 council members present constituting a quorum, any affirmative vote or any passing vote has to be 3 votes. So now you still have what effectively would have been the required number before. So it gives you that exception. And
So if you have a council meeting where you have 4 members present, because one of them is sick or in the hospital, that means a supermajority, well, you still have to have 3 or 4 anyway.
yeah, right.
Right.
So
Yeah, you still have to have 3 to make a majority.
right. But this way you could leave it, you could make it 3, but if it's only 3, it's got to be a supermajority.
It'd have to be all
Or
3.
unanimous.
It'd have to be unanimous.
Unanimous.
Right. Food for thought. Maybe if
Yeah,
we
you
could
can do that.
maybe we come up with some language and see for the next meeting, see how we like it.
You're talking about how votes are passed. How-
Yeah, because that's the thing, that's I agree with the walking, I mean, I agree that there's been so many issues where you have council members that are meeting because it's, less than the 4, and then they're already making decisions before they even get to council, so even not taking our constituent, feedback into consideration when we're going to the council meetings and actually, sharing our insights on the particular item, that's a big problem. But right now, the way it states is if we change that language just to say 3, then when we go to vote on things too, that we only need, 2 to 1 vote. If there's only 3 people present, then, you just need 2 votes to change an entire policy where I feel like you need more voices at the table to be able to change those ordinances.
We don't have a big problem with absenteeism with council, do we? Then when I've ever gone, they're all up there.
No, but
No.
again,
No,
What
but
happened
this,
during COVID?
well, we had to move to virtual.
I think.
So if I understand, like, you're trying to prevent, by lowering it, you're trying to prevent backroom dealings.
Correct.
But by lowering it, you make it to where the votes could theoretically
2 to
be
1.
so low that a backroom dealing would work very easily.
Pretty much.
Yes.
Yeah, that's why you have that exception, that's why the exception language needs to be in there. If, provided however, if it's only 3 members present, it's gotta be a supermajority. Or
And
unanimous.
that, so
Sorry,
how's it now
unanimous.
that you vote? You have to have just a majority of who's at the meeting? To,
Yeah.
when you
Yeah,
vote,
yeah, you always have to,
you have to make a quorum, you get a
We have
majority
to
of
have
it.
4.
so you have to have 4, so it's gonna still have to have 3 votes. Because 2-2 is not gonna be a pass.
And 3 votes would win it now if all 5 representatives were there. Okay, well, that sounds okay.
I want y'all also to think about the language in there, in parentheses, where it says which may include the mayor. Under Type A General Law Municipality Structure, the mayor, although is a member of the council, the mayor is not included or factored in considering whether or not a quorum is present. The reason is because the mayor doesn't get to vote except in the event of time. So the members of the governing body of a Type A General Municipality will include the mayor, but the council does not include the mayor because he doesn't vote.
So that should be deleted then, right?
Yeah, I don't know why that language is
Yeah,
in
that
there,
should be
but
struck.
if you got 3 council members present and the mayor, then you've got a quorum to have a meeting, but.
Yeah.
Can I also add that if we do add an at-large seat, then this is going to have to change, whatever wording we decide on.
everything,
There's a lot of places.
So,
But ordinarily, a simple majority of the council is all that's required to make a quorum. And under state law by default, if you don't have a charter provision that says what a quorum is just simply a majority.
Which is
Even under
3.
the Open Meetings Act, that's what it says. So if you got 7 members, it's 4. If you got 5 members, it's always going to be dropped down to 3.
But we have a provision saying that it's 4.
But we specifically have this heightened quorum, which I thought was kind of weird when I first saw it.
so we're not a Type A.
We're not. The reason why I use that as an example is because that's a structure of government that is the most common form of municipal government in Texas. And it's a form of government that has been used and tested for, since the 1800s.
So what's the principal difference between a home rule and a Type A?
Home rule is we can set it up any way we want. We can have 7 council members. We can have 14 council members.
So Type A is much more structured already.
Type A general municipality is set by state law. Its structure is established by statute, and it only has the powers given to it by state law. And in an era when the legislature hates cities, that's really tough on taxpayers and municipalities.
Okay, so based on your description, we could craft and put an exception in there. If there are only 3 council members present, it has to be a unanimous vote.
Yes, we could.
We could change the language to put a simple majority, i.e. 3, and then add that provision, so that wouldn't happen.
So can we, maybe Sue,
We can go ahead and add the recommendation, and then what we'll do is we'll take it back, think about it, and then we can discuss it and vote on it during the next meeting. So I think there's a discussion around, we understand the why, right? Everybody, I think, is understanding the why. And so I think there's maybe, I think what you're saying is recommending to make it a simple majority, so any 3 members of council, but then adding an exception to where if there are only 3 members present, 3 council members present, then it would have to be a unanimous vote on the contract. Okay.
I can take a shot at the language, or maybe if it's better for David to take a shot at the language.
Ooh, I'm gonna shut it, right?
I can do
That's
that.
why this stays.
He gets paid for it.
I do, I get paid. But we got money's worth, you did it. I just have to prove it anyway.
Yeah.
Aaron could write that down.
Language with added majority provision. Okay. All right, the other item that,
Madam.
yes, sorry, go ahead, Michael.
I'd just like to say one thing, I don't know if everyone in this room is thinking the same way, but when we let 3/5 of the council decide on anything before the council, any item, any agenda item, whatever, aren't we not including 2/5 of the city in that decision? Well, look, if I go and run for council, and I never will, but if I were to do that, I'm gonna be at every meeting. I'm gonna let you know for the next 3 years, I'm gonna be there. Tuesday nights a month, I'm gonna be there for every meeting. I'm gonna vote on every vote that comes up, that comes before the council. That means that it should be introduced to council, it should be put on the agenda by the mayor. So if I wanna, put stop signs on every corner, then I'm gonna say, Mr. Mayor, I wanna put this on the agenda. It's gonna be on the agenda, and by golly, I'm gonna be there to vote on it. If you don't wanna commit to that, you're not representing your district, then why are you running? And should we let 3/5 of the city not be representative for that decision?
I honestly think our
Sorry, I
council,
don't mean to be.
no, I honestly think our council members need to do their due diligence, need to be transparent and not have these backroom dealings in the first place. They need to be
It's
discussing
too-
everything
there's
at
too
the
much
council.
politics, and
So it's
let's not
unfortunate that we're
try
having to have
Let's
this
not try to
conversation.
say that this is not a political organization.
Yeah.
I know.
Yeah.
That just argues nonpartisan, just talking.
Nonpartisan.
With due respect, if 2/5 of the council don't show up, it doesn't matter. 3/5 vote the way they want, the ordinance would pass even if those 2 did show up. So
Then
it's a moot point.
reschedule that decision until the council members are there.
Sorry,
But
what are you
if
saying, Patrick?
3 vote for it, it doesn't matter if those 2 are there or not. You can assume those 2 are nays, but they're still gonna pass.
Yeah,
Yeah, it's still gonna pass,
Yeah.
but it's just a matter of quorum.
I think it's representation is what to do.
But it's theoretical. The truth is, I think if we went back through the history of Farmers Branch, you'd probably find 3 occasions where maybe 2 council members were actually missing.
I was thinking about what you're saying too, and my thought is, like you're trying to say maybe, I think what you're trying to say is maybe require all 5 members to be at the meetings before you can vote on anything. Then what you have is people just skipping town like the Texas House Democrats do, and Republicans, they just skip town so you don't have to vote on something they don't want. I mean, that could happen.
Yeah.
Y'all are shady, that could happen. No offense, not you.
Oh,
Thank you, Brian. Thank you so much.
Politicians are shady.
But I think the majority's still there.
You just contradicted yourself, not you, but politicians. She was a former politician.
She's just a civilian.
I'm sorry.
Feel-
No, but they would, they just skip town.
Yeah, yeah. But I mean, it's unfortunate that we have to even have this conversation because that
If they
shouldn't be
skip
happening,
town,
right? But
then
sorry,
I don't
Patrick,
vote
what
for
were you
it
saying?
next time.
No, Brian made the point I was gonna
Yeah,
make, so that's fine.
yeah. Okay. So we'll think through everything, and again, we'll send these out and that way we can discuss them or talk about them, next time as well to vote on them. So I think, just to reiterate, the recommendation is to add add simple majority language, with addition of majority provision, if only 3 are present.
So,
Unanimity.
Yes.
so will that be in the packet before the next meeting?
Yes.
I'll put some language together and Aaron will share with Joe.
Yeah, and what we'll do is, we only had one last time, and so I think what we should do is just add the different recommendations on a list that will be, so you know exactly what we're voting on for next time, since we're gonna have quite a few this time around. Okay, the second item for 2.14 was, discuss abstentions. Abstentions, so, abstentions,
Lessons.
so abstaining. It's not on here right now, but, one of the recommendations was regarding, the recommendation was,
Was Terry
Need
Lane
to
number
clar-
5? Yeah.
yeah, it's, abstentions, need to clarify language, this came from, Mayor Lynn. Members are elected to vote, must vote yes or no unless a conflict of interest has been established prior to discussion. If a conflict of interest arises, then the member shall not participate in any discussion on that item. I think, he's wanting to add some clarifying language regarding abstentions, that's not currently, in the charter. And so, I think the recommendation was if we wanted to add something, this would probably be the section to add it, 2.14. There are other cities that do have clarifying language around abstentions. Some of them even, advise that an abstention could still be could be technically a no or a yes, depending on what the charter provision is for that city. I actually looked this up because some people use abstentions politically to where it's like, I want to abstain because I don't want to be, I don't want to be called that I voted for or against something because I'm about to be elected, right? That happens sometimes too. And so I did do some due diligence on my end. Pflugerville actually has a provision on voting that advises that voting on all motions regarding official actions of the council shall be by roll call, and each member's vote shall be recorded in the minutes. Except as prohibited by conflict of interest laws or this charter, all members of the city council shall vote yes or no on every action, resolution, or ordinance requiring a vote. So the only time they can abstain if there's a conflict of interest that's recorded. And so that's an example. In some local jurisdictions, an abstention can function as a no vote if the motion requires a majority of the entire council present rather than just voting. So just a couple of things to think about if we want to add something. Go ahead, David.
So we changed the charter the last time around and put it up to the vote of citizens. What it said before was, if you abstain, it's considered a no vote. And so in the last charter review, we looked at it and said, why should it be a no vote as opposed to a yes vote? And so the group thought, there's no justification for it being a no. So rather than being a no or yes, it's 0. Now, I kind of like Pflugerville's, as you say, they have to vote, but how are you gonna force somebody to vote? If I'm over there and I've got a topic up there and I've got 5 of them, and let's just say that David Reed says, I'm just not gonna vote. How are we gonna force him to vote? So you can't. So
Or David Reed says, or anybody says, I actually need more information, I'd like to table this.
well, but if the rest of council says I'm not gonna table it,
If he feels like I can't
right?
make
No,
a legitimate,
exactly. So he's
so
got
I wanna abstain until I get more
Right,
information.
so there's no good faith basis for him under Pflugerville to say, I'm just not gonna vote. So we just eliminated it's a one or the other, and I don't think there's a perfect solution, because you just can't force somebody to say yes or no. David Reed has a good reason. I don't feel like I've got enough, so why should I have to say yes or no?
I must be missing something, because it seems to me an abstention is a no on any motion, because it takes 3 positive votes in the majority to pass. So unless 3 yeas occur, whether the other votes are no or abstentions, doesn't matter, does it? It
Why
still
does it
takes,
show
it
up
still
on the
takes a
public
majority of the quorum
It shows
to
us
positively pass something before it is passed by the city council. Is that not right? So by default, it's a no.
No, yeah, and I think that's what he was saying. It was like that there was a provision before that said an abstention is a no, but it was taken out.
Unless there's two of them.
But it doesn't need to say that.
Two of them could stay.
What was the reason for taking it out?
In theory, you're right.
We didn't think that it was valid to say an abstention should be counted as a no. It's leave it for the people that are there voting to make sure they get to the three vote threshold. And don't just automatically give it one strike. So effectively, I think you're right. You know, in practice, if you really look at it, there's an abstention,
No, I had it.
and 3 of us say yes, 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 no, and then this one is 0, but it's still.
It doesn't matter if there are 3 yeses, it doesn't matter whether the other 2 abstain or say no.
Right. So the real discussion, what the real focus then is back to what Crystal was saying about the Pflugerville is, can you force them, put language in there that more or less forces everybody to vote? And I think that'd just be a hard,
Yeah.
I mean, we could put it in there, but it'd be impossible to enforce.
I don't think it adds value.
Could I interject and tell you what my concern is? Yes, I have seen circumstances where a council member didn't want to be stigmatized by affiliating himself or herself with a specific issue. Have abstained from voting. Under Robert's rules, an abstention is neither a vote in favor of nor against. It's just a non-vote. And you look at the balance to determine if there's a majority vote. More commonly, what I have seen abstentions serve as a purpose is when a council member may not have a, when we say conflict of interest, it has 2 different meanings. Now, number one, I think most of you, when you say it has a conflict of interest, you're thinking about they might have some interest in the outcome. But technically, under state law, Chapter 171 of the Local Government Code contains the definition of a conflict of interest. And it's a heightened standard. I mean, you must own a percentage of the real estate that's the subject of the proceeding, or you must you must have a controlling interest in the company that is asking for an application. Otherwise, or a family member related to you in a certain number of degrees has to have that conflict. If it's not something that you have a conflict in, a legally enforceable conflict of interest, if you have some type of an interest in the outcome that doesn't rise to that level, but would certainly convey an appearance of impropriety. You know, what I advise council members to do is, look, even though it's not against the law, you have to use your best judgment and determine whether or not your participation in this matter may convey an appearance of impropriety, understanding that you have a responsibility to represent the city, to appear as good government, and to be responsible in your deliberations and in your voting. If you believe that you have not an official illegal conflict of interest, but some circumstance that conveys an appearance of impropriety, then you should abstain from participation and or abstain from voting. So when we say if you have a conflict of interest, if you put that in there, and you force someone to vote under those circumstances, that puts council members, elected officials who are doing this out of the goodness of their heart for the betterment of their community in theory in a really compromising position. I'm really uncomfortable with a charter provision that compels a member to vote yes or to vote no. It doesn't give them a whole range of choices. And if they feel really bad about participating, the only choice they have is leaving the room or not attending the meeting and having that counted as an absence against them. So if there is a conflict of interest, the law already prohibits them not just from voting or abstaining, but from participating at all. And I tell people, you gotta leave the dais and you gotta leave the room.
You have to leave the entire, you have to not even be a part of the discussion.
I make them leave the room. I mean,
Well, yeah,
even though technically they could sit in the audience, or they could still sit at the council table and not participate. I make them leave the room, because I don't want them doing this or doing this kind of thing. They want civil participation. So I think it's probably most appropriate to at least have some leeway where a council member who really feels bad about participating, because it will look bad. I mean, if it's their next door neighbor, or, you know, their college friend who's asking them for it, they don't think that they should, I mean, no matter what they do is gonna look bad. So I think they need to have a little bit of wiggle room there. So a provision that says you shall vote yes or no, unless you'll go to jail if you don't abstain, or you
So then
don't.
and just out of curiosity, because I saw several cities have that charter provision that says.
No,
you
it's
have
not,
to vote.
it exists.
Yeah.
I'm not saying that it's not unheard
Yeah.
of. But, you know, if I were on the council and the applicant were, I don't know, someone related to me, my cousin who lives 2 doors down, and I have to vote in favor of, or I have to vote against, it's not a conflict of interest under chapter 171. I'm in a really compromising position.
I would just wouldn't show up. I'm just kidding.
But that's the only choice you have, is not to
Yeah.
show up at all.
Yeah.
Or wait, Mayor, I'm not feeling really good right now. I've got to excuse myself to go to the restroom, and then not come out until the.
Baby's crying, I'm sorry, I have to go home.
Having a
No, that-
babysitter problem.
Yeah.
I have a question.
So.
Which can happen, Go ahead.
Did Mayor Lynn request this?
He did, yeah, so let me read it to you again,
And Reed, Councilman Reed?
no, Councilman Reed was it was the previous provision regarding the
Gotcha.
quorum, yeah. No, this one was Mayor Lynn, it said, abstentions need to clarify language, members are elected to vote, must vote yes or no unless a conflict of interest has been established prior to discussion. If a conflict of interest arises, then the member shall not participate in any discussion on that item, which is already something that they're supposed to do anyways. But I think he was wanting to, see if we could discuss adding an abstention provision regarding, you know, kind of like and that's why I kind of went and looked up, you know, what do other cities have? Because I've never seen one myself, but do other cities have it? And I did see that several, and I just pulled Pflugerville's just because their population was similar to ours, so.
I wonder
Go
what
ahead.
his reasons were.
Yeah, I don't know.
One question, I was rudely trying to talk over somebody earlier. Aaron, does that vote appear on the public record?
So in the minutes, it's recorded as abstained.
It's what?
Not, it's recorded as abstained, not
As
yes or no,
abstained?
but it's
Not yes or
recorded
no,
as
but
abstained,
abstained.
yes. But during the
You should
actual
make your own
meeting,
Decision about what that means.
Okay.
but during the actual meeting, it's a no vote. So it means neither yes or
Yeah, but
no.
if I go back and I said, Aaron, can I see the council
Yeah,
meeting?
it'll say abstain.
Perfect. Okay.
So what about a provision that says, that forces a council member to vote yes or no, that says that all council members have a duty to vote? All council members have a duty to vote yes or no, or to vote on a matter coming before the council, but without prohibiting an abstention. You see what I'm saying? I think the reason, one of the downside, the upside is that council members whose participation will convey the appearance of impropriety should have the ability to abstain without boycotting the meeting. The flip side is council members who don't want to appear for political reasons, don't want to vote yes or no, because they don't want to appear like they're favoring one side or the other, will abstain. That's what I think may be the reason why the mayor is motivating to ask the question. I think he just thinks that some council members may be chickens about saying yes or saying no on an item.
Have we had
But then
that?
go ahead.
As I say, we had that, no, so go ahead.
Go ahead.
Does an abstain change the threshold for passing anything?
Well, that's what I was about to say, I think let's say, you still need
So
three
it's
votes.
just a no. That sounds less harsh.
It operates, it effectively operates.
So if you had 4 people, let's say one council member was out, you had 4 people, 2 abstained and 2 said no, then it just would be a no.
Doesn't
It wouldn't pass. And that's another thing, if people maybe use it as a tool to, but then they could just say no, I don't know.
Boycotting is also a tool, I mean, that's just a political.
That's a political, I mean,
Yeah,
that's
it's a legitimate political maneuver.
it is just like, writers and all that fun stuff, yeah.
Lawyers, well, we know about that kind of stuff.
Writers.
It'd probably be more helpful for us if we had some concrete
Yeah, I don't see that we,
reasons why.
yeah.
Yeah, and ask Terry why, I mean, I don't remember it becoming an issue.
I don't either.
If nobody minds, I'll ask them for the next meeting,
Why doesn't
or
the
before
mayor-
I'll report back to you, Crystal, or we can.
Why doesn't the mayor come up before us under public comment?
I think that would be a good idea.
And petition us, his reason to do that.
I asked him about that, and he said he didn't want to look like he's persuading.
Yeah, I think we're all better not
Yeah,
having
it's
each one
not-
get it, because all of a sudden that we may end up having everyone at every meeting and we're getting lobbied for everything.
All right.
But the
That's kinda
public
what I
has
asked
the
earlier.
right to come up and
I-
participate
Yeah.
in public comment.
Can I just suggest we say on this section 2.14, the second sentence, where it says voting shall be aye or no, just change it to voting shall be aye or no/abstain, because it's the same darn thing.
Well, that's what we're saying, but then when we do that, it would be kind of going back to, because at the last sentence, it says, any council member abstaining from voting shall not be taken as an affirmative or a negative vote. Yeah.
Well, they
And
get rid of that last sentence, because it is a negative vote.
I mean, that's
Well,
the
then it'll go
like,
back to,
yeah, that's the primary provision we put in there
Right,
before.
the people just voted it in. I mean, literally just voted it in.
Yeah, the voters
Voters
this-
just voted
this
it
last
in 2
sentence.
years ago.
That's right, yeah, during the last.
But it's meaningless, it doesn't mean anything, does it?
Yeah. It is what it says.
Okay.
Either
it means
negative or
it's not a positive or a negative, it means you just abstain.
Right.
So if I abstain from something and I was on council and somebody says, oh, you voted no, and I'm like, technically, on the charter, it says, I just abstained. You know,
Right, and there's no coercion.
yeah. So I think what I'm gathering is, we would need more information regarding kind of some reasoning behind it. I think we're okay with just leaving that section, or
Yes.
not adding a section to abstention. Okay, so then, anything else? Those are the only two, items that we had, from council for 2.14. So I think we're safe to move on. 2.15, there were 3. But before we go into those, anybody else had regarding 2.15? Okay, so some of the, recommendations were, or not recommendations, but items for consideration were the use of electronic devices during executive session, that was Mayor Lynn. Discuss process for requesting agenda items for council, also Mayor Lynn. And reevaluate executive session usage, Mayor Pro Tem Bennett Burton, which I think actually is similar to what Mayor Lynn was also wanting to discuss. So the first one, use of electronic devices during the executive session. So this was regarding being able to zoom in to an executive session when you don't know if you're being if technically that session's being recorded. I think that if you want to participate in an executive session, you need to be there in person. Because if I'm zooming, I can have a recorder on, I can have another camera on. It's just really hard to tell whether it is truly a closed executive session when you have someone that is, on Zoom. That's my personal thoughts around that?
That makes a lot
No,
of
I
sense.
agree.
think it
Doesn't
makes
seem
sense.
as fair.
Okay,
Yeah, I like it.
okay.
Without any carve out for someone being ill or not able to attend for any, I mean, both sides of it is, what if someone can't appear in person?
What if you don't have a full quorum, you need that person in attendance by Zoom?
Yeah. You want them to attend, but they physically can't, for whatever reason.
The concern with the use of electronic devices is that a council member may record the proceedings. Or it's not just that a council member may be distracted during the executive session and may not be paying attention. It's that there is potential not of any member of the existing council, maybe former members or future members, may use their cell phone during executive sessions, maybe soliciting advice or recommendations from third parties who are not present, or maybe recording a video or videotaping the proceedings, which frankly would be illegal. This is a procedural thing that has been addressed by the council, kind of in an informal way, where all council members have to put their cell phones and electronic devices in a drawer in the credenza in the council as a meeting requirement for executive session.
You have to do that now?
I don't know if I'm supposed to tell you guys that.
Hands out the bag.
I might get in trouble. But I will say this.
It's not a bad thing.
No, it's not. I just didn't know.
I think it's I kind of like the process, except that I cannot do that, and a broad charter provision that doesn't carve out it, I mean, as long as it says members of the council.
And not
Because
the
I
attorney.
can't function in an executive session without access to state law. or
That's
city
the other
ordinance.
thing, what if you have to look up something?
Oh, well, if you're a council member,
You
oh,
need to
well.
be prepared.
But the city attorney's there, you can ask the city attorney.
But is there an issue with privilege with what's going on? If something is recorded, that privilege no longer
Absolutely
exists?
there is. If I
So
found
we
out that a
can't have
council member, that
technology.
anybody was recording in an executive session, from my first, what's the number to 911? Honestly, I mean,
But
I had
you
a.
can't do that, 'cause you.
Well, with Zoom, you
But
go.
Yeah, you're right, Casey, because I think once you record it, let's say you're a council member and you record it and you leave, it may well be subject to discovery, which otherwise it's not open to production, so.
Oh, there is concern about attorney-client privilege violations. And
So the idea is not to make it easier for someone to do something illegal that they shouldn't be doing in the first place, that if they got caught
Violating the
doing it, they get
attorney-client
kicked off.
privilege, violating the attorney-client privilege is not illegal. It simply defeats the privilege, which means that other members of the council who might enjoy that privilege lose the ability to claim it.
I'm not talking about attorney-client, I'm talking about the executive privilege, you said. You don't want them recording their Zoom.
I don't want them
Oh.
recording, no, nothing.
But if they did, wouldn't they be brought up on ethics charges and whatnot, and there'd be all kinds of penalties anyway?
But that's
If we knew about it.
but if they knew about it, but
If
let's
we
say
knew
somebody's,
about it.
but yeah.
Okay, but what if I have my phone in my pocket and I've been recording this whole thing? Couldn't you just do that at a city council meeting too? And, I mean,
Sure you
Somebody-
could, sure you could.
That's
But if there's a
already-
charter provision that says thou shalt not, and then it's discovered that you are, that's a violation of the charter.
well, isn't there if they get caught recording now, can't they be punished?
It's called misconduct.
So wouldn't that still apply?
Well, technically, there's no charter provision or rule of procedure that dictates the process for sequestering electronic devices during executive sessions. Personally, I think that the whole issue is something that should be a rule of procedure adopted by the council, self-imposed, which is the way that it's working right now. Right now, council members put their phones, and it changes over time too, because a year ago they didn't do that, and now they do. A year from now, they may not, who knows, you know?
Do we have any knowledge of anybody having recorded something and they put it out there that's brought this?
Surreptitiously,
Speculation.
recording, nothing. Yep, nothing.
So if you're discussing ongoing litigation with the city, and you're discussing it with the city councilman, that's a privileged communication that's protected. If someone on Zoom is recording that, that is discoverable. So those facts and details that y'all are discussing can be exposed to the defense or the greater public, which could be a threat and a liability to the city, correct?
Correct, sure.
So we shouldn't allow Zoom meetings for those sessions.
I had an executive session with the board once, and it was by Zoom video conference. And an individual who was clearly in his office, as you can see the partition behind him, was speaking. And in the middle of his discourse, you could see someone's head pop up from behind the partition. It was almost like a cartoon. Right? I don't have a problem with limiting or prohibiting participation in executive sessions by video conference, except when we have a bare quorum present and we need that person there to make the quorum. There's no way that we can stop someone from doing what that guy did in that meeting, just doing it loosely in his office with people present listening in. I didn't know that was happening until I saw the head sticking out.
So David, is this an area that might be better addressed in an ordinance than in the charter?
But what if they don't?
I think, the first sentence speaks volumes here. It says, "The council shall determine its own rules and order of business." Now, is that a separate document? Does the council have its own rules that are
Yes.
exclusive of the charter?
They have their own rules.
Okay.
I'm not sure.
Just last night, thank you very much.
Are they recorded? I mean, I don't remember we ever had a recorded set of rules.
We do now.
They're in writing.
Do
We did it
Brand
just
new.
last
So
night.
this should be
Oh,
Just last
okay,
night.
I missed that.
I mentioned it earlier, if you would like to learn about some of the recommendations, you can tune into
So,
last night's meeting.
honestly,
It's in the packet from last night if y'all wanna go review it.
Was
It
it
has a
covered?
lot of the topics they
That's
requested.
why it was amazing. There was no controversial? Let's
I
say?
It's operational,
I need to
yeah.
watch the
Yeah.
program.
Now, honestly, you guys need to ask yourselves, is this appropriate for a charter provision?
No.
Or is this something that the council should impose on itself?
Wait, so-
I think the
Right
count,
here.
I think as long as it I think it needs to happen, regardless of whether it's here or in an ordinance, or in, you know, I just, yeah,
I look at this as an umbrella policy,
yeah.
where the council shall determine its own rules and all the business. Maybe that needs to be better identified in the charter. I don't know really.
Just for, you know, show of hands, who would want to, regardless of whether it was charter or an ordinance, who would want to add a provision that you could not Zoom into only executive session meetings? Just a show of hands. Okay,
Are we
good.
talking about Zoom the platform or just web conferencing?
Just web conferencing, just not being able, all executive sessions, you must be present in person. Participation.
And there should be a
For the
limit
most
on,
people, okay.
there should be a limit on how many, even regular council meetings, that a person can Zoom in.
There is now.
There is now.
There is now.
That was one of the ones that they wanted us to talk about, but there is
For
now.
you.
Against it in theory, but you know, someone breaks their hip and they're laid up in a hospital bed, but they still wanna do their duty. I wanna give them the opportunity, maybe you say y'all gotta use something more secure than Zoom, and you use headphones rather than putting on speaker. But that's up to the
That's like
council.
6 more paragraphs of the what ifs in every
Yeah.
scenario.
Well, I mean-
You know, like, we can't deal in the what ifs, we have to deal in the majority to move forward.
But if you got two people on a ski trip and they both break their legs.
I know.
You know what I mean? Like.
We'll never accomplish anything in the
Yeah, so how about we do this? We're gonna add it, we'll vote on it next time. It seems like most of us would like to add it, but then we'll vote next time maybe if we wanna add it as a charter provision, or we wanna add it as a recommendation to council to add it to their, as a rule of procedure.
But a Zoom in person wouldn't count for a quorum anyway, did it?
Well, in executive session, they wouldn't take a vote,
Okay,
because the vote has to happen after
so
outside of
this is
executive
really
session.
talking about executive
Just
session.
discussion. Mhm.
So,
Well, why
because-
would we not want a person who's on the council to participate in that?
It's not that you don't want them to participate, it's the potential loss of the privilege and the privacy or confidentiality of it.
Okay.
Important details are discussed, not
Is
for
that
the
not
greater
part of the
public.
professional responsibility though of
You missed that whole
the?
part. They don't trust themselves to not let other people listen in, they're not all on the same.
So I heard about the guy popping up from the.
Yeah.
Okay, I understand.
what is the document that you covered last night?
We
Was
got,
it approved?
last night, the city council approved its own rules of procedure.
Okay,
The rules of procedure are fairly detailed, it's a bunch of pages, probably more than it needs to be, but it does cover, among other things, participation by video conference, a limitation on the
It would
number.
make sense to add that, as they're already adding video conferencing, to add the addition of not video conferencing in executive session. But I'll put it on here, and then we can just say, hey, we prefer it as a procedure and not on a charter. So I'll add it to the list for next time. The other topic of discussion was process for requesting agenda items for council. And that, currently, any 3 voting members of the council may meet in private and add or delete items from meeting agendas without the mayor's approval. Thus, voting blocks are being formed and decisions on items are being made in advance outside of public meetings. We kind of talked about that already. Lack of transparency. The mayor is supposed to control the agenda of the meeting. If council members want to add or delete items from the meeting agenda, they should do so at a council meeting in full view of the public.
Does the mayor, is that spelled out in the charter somewhere that the mayor will establish the agenda for meetings?
Technically, no. I think that was always I'm sorry, when, as far back as I have ever known, it was just a kind of unwritten rule that the mayor has some unwritten authority,
Yeah.
and that
I
was
mean,
one of them.
He's gotta be there for something, I don't know,
It was authority by courtesy. They gave, basically they were afforded that courtesy.
As presiding officer.
Yeah, so.
The rules of procedure that they adopted last night contain provisions that deal with that. The only provisions that talk about agendas in the charter is, which we kind of glossed over, but didn't talk about, is 2.13, where it says special meetings of the council may be called by the mayor or the 2 council members by giving written notice. That's just calling the meeting, not setting the agenda. Agendas are typically set at the request of the mayor or staff, predominantly staff. Many cities have rules that say that any 2 council members can place an item on the agenda, but not 3 in a council of 5, because 3 getting together would be a quorum in violation of the Open Meetings Act. So a lot of cities will have provisions in their rules of procedure that say any 2 council members or the mayor can place an item on the agenda.
What's the current process now? Can you share that?
Yeah, I mean, it's the mayor, city manager, or any council member. 3 council members? Okay, or any 3. From a political
Because we have a
perspective-
4-person.
Right, yeah, 4 is a
Quorum.
quorum, if 4 had to do it, it would be a violation of the act. So, yeah, understand that in a lot of cities, the control of the agenda is a hot political issue. That is political authority. The person who gets to dictate what's on the agenda, has a pretty significant position of responsibility and authority. And so, if the mayor or city staff refuses to place an item on the agenda, then it becomes problematic. So a rule of procedure usually exists that allows less than a quorum of council members to agree to insist that an item be placed on an agenda. I have a city now where any council member can place an item on the agenda, any 1 council member, and it becomes a problem because the mayor doesn't want that item on the agenda, and that council member does, and then that council member wants to put the mayor up on charges because she changed it. It becomes a huge political deal. So it needs to be more than 1 council member insisting. But even then, I mean, you need to ask yourselves if this is something that is appropriate for a city charter, or if this is an issue that the council just needs to work out for themselves and get it right. That makes, yes?
So David, was that resolved last night?
Well, yeah, we adopted the set of rules, we adopted rules of procedure that say that the mayor, city manager, or I'm looking at Aaron for confirmation, any 3 council members can place on the agenda.
So any 3 members can place it, the mayor can place it, city manager can place it, or if it's requested at a public meeting during future agenda items.
We don't even have to worry about it.
Yeah.
Because it was,
So it's a non-issue.
so it's a non-issue. Perfect.
Right.
Well then,
Should have said that right from the start.
I know.
What did you talk about?
If, if we wanted to make a recommendation to change, we could recommend they change the rule of procedure. It's a much easier process than the charter.
Yeah.
Right, yeah. But these are things that council work out for themselves.
Okay. Perfect.
That first sentence says,
Yeah.
No, you see, you're
Okay, those,
making it simple, don't do that.
and I think we already talked about executive session. All it says is, reevaluate executive session usage. I think that was from Mayor Pro Tem Bennett Burton. Did they talk about executive session usage procedures last night?
No, not that I'm aware of. Did they?
No, we don't need to talk about that.
Nothing
Okay.
specific really.
I'm working on that. That's operational more so than it is structural. It's not necessarily, but calling executive sessions and what's done during executive sessions is often problematic.
Because I think my issue is that you shouldn't be calling executive sessions unless it's for personnel, litigation, property, or economic negotiations, development. But I feel like there have been executive sessions on
13 times.
on things that were outside of that, where they should have
Not
been,
12, but 13.
well, that should have been handled in the public.
I understand this. Some cities, not Farmers Branch, I'll make that clear from the start. Some cities kind of abuse the privilege of being able to call closed sessions. Closed sessions are only allowed under those purposes that the Open Meetings Act allows it for. And there are only a handful of exceptions, and you touched on exactly what most of them are. There aren't many others. If you do not have an executive session for any of those purposes, it's a criminal offense. Anyone who participates in the meeting, even if they didn't call it, if they're just there, commits the criminal offense. All I keep saying charter. All agendas are reviewed, or draft agendas are reviewed by staff first. I am going to be, after the last meeting earlier early this month or late last month. I'm gonna be reviewing all of the agendas before they're posted that deal with executive sessions. And I'm going to be moving more towards having more things done in open session than in closed session, even if we could otherwise have had them in closed session. There are some things that needs to be in executive
Sure,
session. I mean, personnel matters absolutely always in closed session. Attorney-client privilege information, we're not gonna do that in open session, period. Economic development negotiations, or real estate purchases, you understand that open session discussions impairs our bargaining position or may discourage investors from coming to the City of Farmers Branch.
Yeah.
So, you know, there's a balance that we have to strike between whether or not it should be in open session or in closed session. Some things we're going to do it in closed session, period.
No, and I think we all get that. I think just historically, I've never seen so many executive sessions on things, especially with DART, where I think we could have handled it in.
Dart is one classic example.
Yeah,
I know that everybody wants to have that, wanted to know what was being talked about in closed session, but
Dying
you
to know.
you understand, well, you know, there's some things that, a lot of that was legal advice. So you understand that we
Yeah.
were in conjunction with them. It was a really complicated process.
Yeah.
We were in the process of negotiating a local agreement that was worth about $11.6 million.
well, it makes me feel a lot better that you're gonna be looking at all of the different
Well,
executive session agendas, but.
Going,
Yeah.
the DART deal was complicated, and I understand that there's a great deal of political controversy.
Yeah.
But the executive sessions that we had were necessary. It was proper to do it in executive session.
Understandable.
And so, but
Okay.
going forward, I'm gonna tell you, we're gonna have less executive sessions going down the road.
So I think that last, section that, was brought up by Councilmember Burton, I think is pretty much was covered. Or would be covered under that, because you'll.
Well, the one that's, I think what she said, I don't disagree with what she's asking, and she's right in asking about it. I just am not quite sure that it's a structural change to
The
the
charter,
charter. as it
okay.
is.
Then we'll just kind of kick that back to the council. Okay, all right, that is all that was advised for recommendation from council. Sorry?
Sorry, we had like a 5-minute break.
Oh, yes. Well, yes.
I think we're gonna be done within the next 5 minutes.
True, that is true, we can keep going and going.
Yeah, honestly,
Section 2.19 might take a while,
oh, you think so?
maybe.
You don't have any,
Or actually, I'll just go, y'all can continue.
oh, no, let's take
No, no, we-
a 5 minute, you wanna try to get through this today? I think
What are you trying to
maybe,
get through, just section 2?
yeah, just section 2.
Oh, yeah.
Yeah, okay, let's take a 5-minute break. Sorry. Do what?
There's one on the
There
dais.
you go, I'll just steal it.
You'll borrow it.
I'll borrow it. There you go, I won't steal it, I'll borrow it. Marilyn won't. 2.15 is the next section. Sorry, no, 2.16, my apologies. We already went through 2.15. Any comments, questions, concerns, changes, 2.16? 2.17. All right, next, 2.18, we do have one from Brian, he had to go. But he wanted to see if there was, a way because right now the audit, is at will, wanted to see if there's any way to post it somewhere. Have you seen that
Is
at
it,
all?
you said it's at will?
Or it's like upon request, sorry.
I'm almost certain that there is some language somewhere that says that there's a deadline by which it needs to be provided to the city council and posted. I can't tell you where that is.
It says a copy of the audit shall be kept in the office of the city secretary, subject to inspection by any citizen and officer during regular office hours.
So
So it's not posted, it's just you have to go during office hours, and I just don't know if that's a norm or not, I'm not sure.
And I may be mixing this up with the budget.
No, budget's required to be posted online, and a whole bunch of other stuff. Audits, not necessarily, but if you look at the second and last sentence of 2.18, it says, "They shall not maintain any accounts or records of the city business, but within specifications approved by the council shall," am I reading that right? Post audit? Post audit the books and documents? What is that word? What does that mean?
Is that a typo?
I've never seen it before.
That's, not a term I'm familiar with. I'm sure, I felt your eyes boring into me, but, I'm like, that's a good question, that seems like a legal term.
I don't know what that means.
I don't know, what post audit doesn't mean anything to me.
I think it was supposed to be either post or audit, or shall post and audit the books, but but there's a change that probably needs to be worked out.
Maybe you said that's a word, David, I've never heard that before.
I'm gonna look it up all the time.
Yeah.
I'll look it up on AI.
I know, I hate AI.
Okay, let me look at it.
Oh my gosh, sure enough, a post audit, oh, it's post space audit. Is it?
So we need to correct that.
Dash on it.
Transactions, projects, or processes conducted.
There's just a dash missing.
What I was trying to do is that at some point after it's finished,
I still haven't heard of
they go
post
back
audit.
and,
There should be a space.
After the audit?
yeah.
There should be there should be a space between post and audit, yeah. So what were you saying, I'm sorry?
But budgets do have to be posted online, audits not so much. If you wanted that as a charter provision, then by all means make that recommendation.
We do have the ACFRS posted.
The what?
The annual comprehensive financial report.
I mean, so why would it,
Which comes from the, right?
Yeah.
And couldn't somebody just email and ask for it? Get it?
well, yeah, but it
Yeah.
says a copy
Yeah.
was kept.
You're asking too many questions.
But Dan, it says, a copy of such audit shall be kept in the office of city secretary, subject to inspection by any citizen and officer during regular office hours. I don't think, the charter, allows for you to share it. If I'm reading this correctly, right? Right?
There's state law that requires budget to be posted within a certain amount of time. But I don't think there's, they do know better, state law that requires the audit to be posted as opposed to be available because it goes into,
Right. Well, the audit's always available, but not necessarily posted online.
So if somebody, as I read it right now, if somebody wanted to get a copy of the audit, they would have to go during office hours and see it in person.
Or they can send an email on the public information.
Or do a public.
or they need to get a ride.
So Ryan brought it up, is just, hey, can we post it? Is there any harm in posting it? And so,
I will say that posting it, check with the CPAs on that and make sure that there's no problem posting it, because they're putting their opinion on there. I would imagine they have no issue with it being posted either, but.
Good question.
yeah, that's a good question. Okay.
Yeah.
Aaron, do you think we could get some more information from the CPAs if they think there would be any issue with posting the audit?
I'm gonna speak with our finance
Or
department.
finance department, yeah. Or accounting department.
Seems like that would be the whole purpose of the audit.
Yeah,
Right.
transparency, right?
Yeah.
Just indicate
But that's a good,
Indicate that in the very last thing.
This language doesn't preclude posting it, it just doesn't require it.
Mhm.
Correct.
Yeah. Okay, then for 2.18, get info on posting for audit. Okay, anything else for 2.18? Other than adding that space between post and audit?
No. Yeah.
Okay, 2.19. You have something? Okay.
I do, and it probably goes 2.19, 2.02, 2.04. And I would throw it out for future discussion. But over the last 6, 7, 8 years, we've had four or five council members just quit during their terms, which is, almost never had that happen. And to my recollection, none of it was health-related, moving away related. It was they decided they just didn't want to continue on. And I think it would be a benefit to your constituents, benefit to the city as a whole, is to have something that discourages somebody quitting midterm or 6 months before the end of their term, or 6 months into their term.
6 months.
And we've had all of those situations, and so I'd like to have us talk about having a provision that basically says, if you run for office and you quit, you stop without a really, and I don't know how we draw the line of what's valid and what's invalid, but think about having some provision that says if you stop, you leave your position, you're not able to run for re-election or election again, either ever or for quite a substantial period of time. So,
Devil's advocate, how does this, how do you write that with, you don't want people to be able, you want people to be able to abstain from voting? And now you're saying, so you're saying you can't compel them to vote, but now you gotta compel them to be.
you made a commitment. You made a commitment. You ran against other people. You had an election. You told people, hey, vote for me because I'm here for you. And,
So then you have to
and
vote.
trust me.
So then you have to vote. Then I'm compelling you to vote too. I'm just saying.
I understand. I think it's a bigger gravity than just voting. So, I mean, again, this is, since we didn't have this, I think it's worthy of kind of a deeper discussion about.
Sure.
Because it's become too common. I mean,
Expensive too.
But didn't we already talk about this?
Because, yeah, because
We talked
we
about
have
it
to do the
last
runoff
time.
or the special election.
They can pay for the special election.
I forget.
They can pay
Right.
Make them pay for the special election.
Well, we talked about what happens if somebody steps down and how you feel it, but we didn't talk about if you're that person stepping down and you're doing it because
Yeah, we talked.
you just don't like the acrimony that you've been a part of creating, or you decide that, I wanna be closer to my grandkids, or you decide to prepare for another profession. That to me is a whole different issue, and we need to try to discourage people, especially, when you're not that far from the end of it, or you're at the very beginning of it. There are
change this idea, you pay for the special election.
But I thought, okay, now correct me if I'm wrong, but last time we did talk about holdover provision, and we did talk about, because I think Councilmember Lynn asked about, as soon as they resign, they should vacate office.
That's vacating office, but I'm talking about, if you do this, you can't go back and say in 3 years, well, I wanna run again.
Right.
I think there should be consequences to you
gotcha.
stopping in the middle
Gotcha.
of your term and not filling out the full term, because there are people that relied on you, there are people that supported you, there are people that ran against you, that lost, and when you run for council, it's a lot of work if you take it seriously. James, you did it, you know good well, it's a full-time commitment, and so.
So you're wanting to add a provision to
the charter that basically, we'd have to work some language out, but it discourages somebody not completing their term, short of there being
like a consequence?
disciplinary.
It's a deception thing that happens when you're not going to be fulfilling the whole term for some consequence, some reason. This happened just recently, where you were.
Where that person knew they were not gonna be
They're
able to
not
fulfill their
gonna
term and
be
they still
doing
ran
this
for
and
office.
this. And then, what about the people who walked for them, or
Right.
who did the work for them?
Right, yes. So-
There are some states that have, and I don't know if Texas is one, but I know that there's some states that you post a bond if you are going to run for office.
Yeah, good
Surety
idea.
bond.
You can get it to keep you from
From
doing just that, but I don't know if that exists in Texas.
I've never.
Any other
Have you
cities
seen-
have this?
Yeah, I was gonna ask.
There's some other
you,
states that have them, I know that.
Have you seen any
Yeah, that's
provision like
one way to
that?
make sure nobody runs for city council.
No, and actually, bonds are actually super cheap, but if you actually have to collect on them, then you gotta pay them back.
So,
Yeah.
That'd prevent it.
That's the hard part, isn't it?
The personal indemnity side of it is what catches you.
so I think, I would wanna see what pet language would look like, because I don't know if that would discourage somebody from, like, let's say I got accepted to medical school, all of a sudden. Not that I'm gonna.
Well, you would be taking tests for 2 years prior to.
That's
so
true,
you
that
would
is
know
true, so
ahead
I
of
wouldn't
time.
run it for
Yeah,
office,
that-
you
that's
know,
not-
knowing that I'm already got accepted
Well,
here.
how would that affect someone who decided to run for mayor after they got elected as council? I mean, are we,
So that, no, that's, see, that's a legal obligation. If you decide to run for mayor, you would have to give up your.
Yeah, your council seat.
okay, so if you run for another office, that's
Right.
not.
Yeah, that's not, you have to vacate.
Right, so that's
So
a.
you're talking about people saying, oh, I don't like this, I just wanna quit. You know, is that what you mean? You know, people.
Inefficient.
Or that they know they're not gonna be able to fulfill it because they knew they were gonna move and they shouldn't have in the first place.
You've already started studying for your MCATs.
I was
You've got
I
your
was at
MCATs
some
that are
meetings.
needed a week after the election, and if you've had your MCATs, then you're
Yeah.
pretty sure you're gonna get into medical school or whatever it is that MCATs.
Who's that?
Martin.
So.
So going back to, I think we're losing the room. Okay, going back to this, what would be a recommendation that you'd like us to consider? Or would you wanna create, I don't wanna see some language before I even consider something like this, cause I wanna think through like pros and cons and I need more time and information.
No,
What if you just said something simple like, you can put it in legalese, but, saying that if you quit, cancel in the middle of your term, you should not be eligible to run for office again, ever, or in X years, or
10 years?
is that too simple, or maybe?
That's effectively what I'm thinking. We're gonna have to wordsmith it more than
I was
that.
writing it down when you were saying.
But it only applied to Farmers Branch, you couldn't stop
Correct.
them from running.
Yeah.
Right, ineligible in Farmers Branch for 10 years.
Well, it seems like there would need to be a medical exemption, because somebody might have a real problem.
Oh, yeah.
Yes. There are legal exemptions and then some kind of medical exemption, and that's.
We can if we want to.
I think it's a good idea.
You could envision all kinds of personal hardship issues.
In most
You have
cities,
a spouse,
there's,
you
you can't stop someone from voluntarily resigning from their
A lot of
elected
things.
position. The law imposes a duty on you to serve if you get elected
There
there.
are legitimate reasons, and then.
We could, if we wanted to,
He's trying to explain something.
we could, if we wanted to, establish a disqualification from office if you've ever voluntarily resigned from the council. It's hard to carve out exceptions. I mean, the circumstance you're talking about makes sense, but that's not every circumstance under which someone may voluntarily resign. We're not talking about running for a different office, which is an automatic resign through one resignation. Will it only be voluntary resignations? You could limit it to a resignation submitted within the first year of a 3-year term, or the last year, or any time in between. You could, if you wanted to, create an exception that would allow, since the council is the judge of the qualifications of its own members, that would allow the council to excuse that, but that's not a good idea. I forgot I even said that, because I can just imagine all the problems that process would create. You could do it if you wanted to. I've never seen it before, but.
My fear is the exceptions swallow the rule. That it's so hard to draft something that provides adequate exceptions, like Pat was coming up with multiple reasons why you might resign. I think we've had enough issues happen that it's worthy consideration. Ultimately, the question is, can we draft it to where it's actually effective? And we may not be able to. But again, if it's the will of the group to look at it further.
I would say it's worth looking into further. I think trying to come up with some language, because I agree with you, it's become more problematic, and I think structurally, we should say, this is important to us as, constituents, that if you're applying for this, you gotta be in it for the long haul, or the 3 years.
Yeah.
I'm fine looking into it. What always bothered me recently is, when you have a man or woman that resigns and they still have full voting rights and they're not even, they don't live in a city, they don't represent their district anymore, and they're up there voting, making big votes, swing votes that affect what we all pay or this and
Or a
that.
person that doesn't even live here anymore.
And
That pisses me off.
No,
I mean, that makes me mad.
Yeah.
I agree. I agree, Todd. I'm with you.
I like the first time.
Okay, so then we'll talk about this next time, and then we'll just put in some language and see what everybody thinks, and we'll vote it up and down. We have a number of things that we'll have to vote up and down, So Aaron, if we can, before I kind of close up this discussion, anything else on, that last provision, 2.15? Section 2.19? Anything else on 2.19? So Aaron, if we can get a list of all the potential recommendations that we will be voting on next time, just so everybody has that and can study it. And then I would wanna definitely discuss this last one more, just what the pros and cons of that would be. And so be ready to have a discussion at the top of the meeting next time on all the different recommendations. The last item before we adjourn is any items for future consideration. And this is a time where maybe you have something that you may not know exactly which section it may be on, but you want us to discuss it. This would be the perfect time to share that, so then that way, between Aaron and our city attorney, we can then figure out maybe when the appropriate time is to discuss that item. So, anything? Did you have something?
I got one, but I'll wait, because I've talked a lot.
Are you sure?
I'm sure, so if somebody else has something we'll bring up, I'm gonna wait.
Okay. All right, anything else that anybody would like to discuss before we call for a motion to adjourn? Go ahead.
So, if anybody was following the city council and the city over the last 2 months, we had a vote initially to let the citizens decide if we were going to stay in DART or not. And it got to the point where DART was not negotiating, was not talking with the 6 cities that were trying to get something worked out. You know, and I won't go into lots of details because it's for another discussion, but DART came to the table very, very late, and we had very, very little time to really be able to review what they were telling us and get details hammered out into the proposed agreements that we came to the table at the last minute on. And the 6 cities that had joined together to try to put pressure on DART, then fractured because they didn't have time to get back together and meet, is basically, I think, what we ought to talk about, similar to sections 710 in the election code, establishing a board to review the borders for the districts every so often, and then miscellaneous provision 920 on the charter review. Why we're here is having a similar type of provision that we can only vote every 6 years, is to have a provision basically requiring the council to start the process at least a year and a half ahead of time, if not 2 years ahead of time, so that now we don't get stuck in that last minute where DART finally came to the table. We really had no ability to keep our coalition together and analyze it. So for future discussion.
So can you repeat those 2 things that you want to discuss? One is regarding the putting together a similar advisory to start discussing the contract, it's like 2 years before it's up.
Right.
For discussion. And then what was the first one that you mentioned? Or was that it?
That was all one,
Oh, okay.
one topic.
So that was it, okay.
Is it specifically towards DART or anything that involves a certain threshold
No,
of financial obligation?
It was DART, because this was a
It's a contract that we have to review every so often.
Every 6 years.
Yeah.
Right.
and only every 6 years. So now we're stuck for 6 years. So if what DART promised us, it wasn't a done deal, that it still had to be approved at 4 different levels above them. If it doesn't come to fruition, that $11 million we may not see, but we don't get to do anything again for 6 years. So this, by putting something in there in stone that the city has to start working on it sooner, can keep us out of that, maybe keep us out of that kind of scenario in 5.5 years from now.
Could be like a threshold amount, perceiving any other kind of contractual agreements the city might get into in the future, like a DART situation, that we have to have advisory board and so on.
I think we have so many though, I don't know.
Yeah, I'm not
Like that much
envisioning-
money, it's a
Oh,
huge
like
amount of money.
above a certain amount of
Exactly.
money, yeah.
So therefore, you don't leave it in the hands of the council exclusively.
Because our tax dollars,
Exactly.
yeah.
Right, because we're paying $25 million a year to DART, and we've put in over $500 million since we
So we
joined,
need to see where that,
and so there's a lot of concern about.
Before you put something in.
Anyway, we'll save any more for future discussion.
maybe at the end under Miss.
Has there been a board member appointed For Farmer
We
Springs?
get half a
To
vote.
the dartboard?
We get half a
one now.
No, we
5%.
We're gonna get one.
We're going to get one.
We're gonna get a seat at the table, whether that means we actually get to vote is not yet set in stone, I believe.
No, we do. I think, yeah.
Well, it better be.
Yeah, that was part of it. No, that was definitely part of it, yeah. So now we don't get half, we get full. And I think 'cause our representative was,
You know,
was
Mr.
Plano.
Moran, I think, is,
Very, very small percentage.
Yeah,
Us and Addison together, and Addison was voting to still get out.
yeah.
I think I read where it was, what, 5% or something,
Yeah,
and
that's
the
right.
bigger cities get a lot bigger
Yeah.
voting say, and so we still don't have much of a say, but we had more than we had, so. you're
Yeah,
right.
we have a full vote.
There you go.
Okay, anything else for future consideration? All right, I will entertain a motion to adjourn the meeting.
Please.
Third.
So moved, second. All right, all in favor, say aye.
Aye.
Any opposition? Thank y'all so much, so much.
I don't
I appreciate
know.
it. No. No, no.
I'm abstaining.
Thank y'all for your time.